Let us begin. Welcome again, and thank you for joining this live webinar on child custody and child maintenance, where I'll be discussing on these specific issues and topic. However, if you have specific questions, feel free to pose it and I'll try my best to answer it. With the lockdown, COVID-19, and the restrictions on movement, many challenges have come about when it comes to the issue of child custody and child maintenance. As I mentioned in yesterday's webinar, the word custody is no longer being used legally, but I still continue using it. The legal term now is care and contact, no longer custody and access. But for the purpose of this webinar, and many people do not know those specific legal terms, and they're used to the term custody and access, I will play around with those terms. I'll more than likely use the word contact as opposed to access. I had a few webinars yesterday, specifically yesterday with a practicing attorney from Durban, and she agreed with me that when it came to COVID-19 and the lockdown, our jobs of legal practitioners became more relevant because there was major challenges in the protection of minor children's rights, the protection of parents' rights, and the issue concerning general parental rights and responsibilities. The courts were challenged to us. It was very hard, or it is still hard to obtain, justice or legal recourse for the sole reason that there are certain regulations in place, certain practices in place, where the courts are trying to limit the spread of COVID-19, and being heard or obtaining some form of justice from the legal system becomes a bit harder. For example, you might have a criminal matter pending against you and they postpone this matter to another date. You may have a pending maintenance matter and they postpone those matters sometimes indefinitely, sine die, and you will have to be informed later on of that date. Urgent applications to the High Court or to the Children's Court and so on is becoming very difficult. However, nonetheless, they are still being made and the courts have a legal obligation to attend to your matter. But having said that, at the same time, it is expected upon parents to act reasonably and understandably, knowing that we are in a pandemic and it is in no one's best interest to play the system. I do not advise you to do that because judges know what's happening, magistrates knows what's happening, and if you are trying or attempting to renege on your maintenance obligations or your child custody rights and so on, or obligations, the law will pick it up, and once these matters are presented back to the court will obviously know your attitude and act accordingly. So please, we're in a pandemic, be reasonable with the other parent. And when I say reasonable, and maybe I can provide an example, we know that during this lockdown period, kids are longer with one parent. Kids are on holiday. They're costing more money. They're eating more. More money is required, for argument's sake, for entertainment, maybe internet, whatever the case may be. They flush the toilet more. They use more water, and so on. Is it necessary for one parent to approach the court in order to convince the other parent that there are more expenses in relation to the minor children? It's clear. If you have a maintenance order which you have to adhere to for the sum of 500 Rand per month or 10,000 Rand per month, whatever the amount is, and the minor child is now more in the care of the other party, where the school holidays has been extended. It has already been extended initially. This is the longest school holidays, December school holidays, children had in many years, maybe decades. Nonetheless, expenses are high and expenses are still being incurred for the minor child. You as a parent needs to be responsible and need to know that, and cannot hide behind the fact that the court order says you must only pay 500 Rand per month. That 500 Rand per month might be adequate under normal circumstances, where the school holidays are a certain period, a few weeks, but it's not adequate during this lockdown period. Even if we go beyond the school holidays, kids are most of the time at home. They go to school every second day. They're online all the time. It costs more money. Why should the primary caregiver approach the maintenance court in order to increase that maintenance order, despite its common knowledge that the minor children are costing more during this lockdown? So that's my comment on that. So things are different, things have changed. Regarding the change in circumstances of child custody rights, another issue. During this pandemic, minor children spend more time with certain parents or less time with certain parents, depending upon the certain circumstances. Yesterday, in my discussion with the attorney, I posed a question on catch-up contact. Catch-up contact in the sense of whereby a parent was was limited in his or her contact based solely due to the pandemic. For example, at the start of the lockdown, the law was clear. Minor children should have remained in the care of the caregiver they were at the start of the lockdown. Therefore, if a father, in my example, always had contact with a minor child only on a weekend, once a month, and the other parent cared for the minor child, of course, for the rest of the time. But let's say lockdown started on the father's weekend. Maybe they live a bit far apart. They received notification that the lockdown came in and they did not understand the regulations. But all of a sudden, midnight came in and the minor children were with the father. The law specifically stipulated, despite a court order saying something else, the minor children should have remained in the care of this father until those regulations were changed. And that was a few weeks later. And despite that, parents still quabbled and parents still refused the other parent time and contact to the minor child. Where I'm going to with this is, there is no such thing basically as catch-up contact. Parents need to act responsible and reasonable. They cannot hide behind a court order. So let's take that scenario, for example, that example, and take it further. Let's say the mother, who is a primary caregiver, had the minor children for that first 3 weeks during lockdown, and the father, who was supposed to have contact to the minor children, could not exercise contact. Let's take it further. Let's say there is interprovincial contact, whereby the father stays in Cape Town and the mother stays in Johannesburg, and the kids usually come down to the father for half the school holidays and so on. But it could not happen because of the regulations limiting interprovincial travel of people. During the year of 2020, clearly one parent would have had much more contact to the minor children than the other parent. The one parent would complain and say, I had little contact to the minor children. Please give me some type of additional contact. Despite it being a court order which stipulates how much contact I'm entitled to, or when I'm entitled to have contact. And the mother, for example, in my example, they will say, no. The court order says the second half of the June holidays, the kids are with me, and that's it. Or the court order says that the second half of December holidays, the kids are with me. If you could not, because of the law, exercise contact during the first half of the December holidays, that is your fault. That's unfortunate. Sorry, not your fault. That is unfortunate. But I'm not here to forfeit any of the contact which I am entitled to have in terms of the court order. So with my discussion with the attorney yesterday, she advised me, and I agree with her. The courts know the reality. The courts know that we are in a pandemic, we're in a lockdown, and clearly, there needs to be a change in circumstances. or a change in the manner in which parents care for the minor children. You cannot hide behind a court order if it's blatantly clear that the child needs to have more contact with other parent, but you are using the court order as a means and a mechanism of limiting contact. Therefore, on that note, please be reasonable, please be understandable. We do not know how long this pandemic will continue. Could be many more months. I don't know. My guess is as good as your guess. However, we live in a reality where I honestly and truly believe that the minor children are being damaged. They are losing out on education. They are losing out on contact to the parents and so on. And therefore, we need to make it as comfortable and as good as possible for the minor children in order for them to enjoy life and live a life as normal as possible. But limiting contact to a parent because of this lockdown, despite a court order, because the parent did not have contact during a specific period of time because of the regulations, would not be in the minor child's best interest. And at the same time, why let one parent suffer and struggle despite you knowing that that parent is incurring more expenditure during this lockdown? Having said that, if you have any questions, please feel free to pose it. I'll be happy to answer it. Please comment where you watching it from. And as mentioned earlier on, you need to pose a question on the Advocate Muhammad Abduroaf Facebook page. You can see it over there, www.facebook.com/ADV Muhammad Abduroaf/live. That's where you can watch a video. But if you type in that link, you should be able to come to the relevant page. We try our best to post or advertise these webinars before the time. Unfortunately, we can't have a fixed time. I need to be in court, things happen, other consultation and so on. So at least the day before or the morning early, I'll know my schedule and I'll know when I can go online for about 35 to 40 minutes. And you should get a notification of that. If you are working during the day and you are extremely busy, like all of us are, and everybody should be, keeping busy is the way to survive. Please visit that page again and you can watch previous videos. They are all stacked there and you can catch up. You do not have to watch it live. You can watch it later. While we're waiting for people to pose questions, I see a question came about now. Let me deal with that question. The question goes as follows. Can maintenance be reduced because he had another child? That's a very interesting question. And I'll answer the question, and a question which arises regularly. The quick answer is yes, it can be reduced for the sole reason, and it doesn't necessarily have to be reduced. It can be reduced. It's possible that it can be reduced. It does not always mean it should be reduced, or there are valid reasons for the reduction. Let's say, for argument's sake, let me first deal with a scenario where it will not be reduced, and then we can go further from there. Let us say the father in this scenario has to pay child maintenance, and child maintenance is an amount of 500 Rand per month. He clearly can afford it because he earns 50, 60, 70, whatever amount of 1,000 Rand per month. So it's affordable and he can do that. And the mother can afford it as well. Let us say tomorrow he gets another child. Or 9 months later gets another child. The obligation, or the people who is obliged to care for the new child, is of course him. So his expenditure would obviously incur, and obviously the mother, the new mother of that specific child. However, if the amount is, insignificant, he's paying for his new child 300 Rand per month, 200 Rand per month, and he's still earning 50, 60,000 per month. Are we going to deal with rands and cents over here? So under those circumstances, I would say, there's no valid basis to approach a court to reduce it by 100 Rand if you really can afford it. But having another child, nobody limits you to do that. If you have one child, you are not limited nobody can tell you can't have another child. That's just being silly. People go on with their lives and move on with their lives. You cannot say, because I'm paying maintenance for my one child, which I had in a previous relationship, I am limited in having new kids, other kids, because I must continue paying for that. That's not how the world works. But you obviously have scenarios where fathers are fathering kids left, right, and center, and they do not pay maintenance for any of them. The principle would be applicable here would be the father earns so much money. He has one child, which he always maintained in terms of an agreement, a court order. Now he has a new child. He is incurring more expenditure. He is. And we have to look at the facts of the matter. If at the end of the day he's working very hard and he can only afford to pay for his first child 500 rand per month. Now is another child. He has a legal obligation to maintain that child. Should the new mother go to the maintenance court, the court will make a maintenance order for him to pay maintenance for that child. So what do we do then? In order for him to earn his salary, he has to um, buy clothing for his work. He needs food. He needs a place to stay, and so on. So the long and the short of the matter is, yes, it is possible that the court can reduce the maintenance for the first child based upon the fact that he has a second child. But it all depends on the mathematics, the economics, and so on. If he is incurring additional expenditure for the second child, we can't. The law doesn't say, okay, second child, you have a lesser right to maintenance from your parent, like the father, because the parent has a first child, or the first child has a better right. We have to look at all the mathematics, look at all the equations, the income, expenditure, the father's, what he does, does he smoke regularly, does he consume alcohol a lot, does he entertain himself a lot? So those are the factors we have to look at, and that's how a maintenance inquiry works. We look at the man's lifestyle. But if the man earns 1,000 rand per month, he bare minimum, whatever he earns, he goes to his accommodation, which is totally reasonable, transportation, work, etc., food. So that's bare minimum, and because he earns 1,000 rand per month to the bare minimum, he has 300 rand available to maintain for maintenance, to pay for maintenance. Now a second child came out about. He only has a 300 rand to play around with. Can we say that the second child should not receive any maintenance? We cannot say that. That will be improper. He's not curtailed from having maintenance, but it is only 300 rand. He doesn't waste money on cigarettes, on entertainment. Salary goes to small room accommodation, to or shared room accommodation, to a limited amount of food, and that's it. And it's 300 rand left, which he initially paid for the first child, but now is the second child. That's a scenario if I should apply it, whereby there will be grounds for a reduction of paying maintenance for the first child. Yes, we can say he must find a better job and a new job. Yes, and he's doing that, but that's a scenario. That's my general answer. Obviously, the facts might be totally different where the commenter is concerned. There might be a totally different financial scenario whereby the person who is paying maintenance can afford it, and he is just hiding behind the fact that he is now a father of a new child. We need to also look at the circumstances of the new spouse. How are they married? If he married a wealthy woman, income into a property, he became wealthy overnight. The new woman, the new wife of the father, has a legal obligation to maintain the father and the minor child as well. So those are all the factors that we have to look into. Oh, I have another comment over here. Says thank you. Wow, a lot of comments came in now. I should keep my eye on this one. I have another additional question. Can maintenance be reduced because ex and new wife ran up more debt? My Sunday expenses are high because he has special needs. The maintenance should not be reduced on principle that someone now ran up debt. Let's say the maintenance is 100 rand a month, but this party goes to the retail stores and buys an item of clothing on credit every month for 100 rand. And because he or she does that, they are incurring more debt each month. That will obviously be improper. If you look, so the maintenance should not in principle be reduced. There are ways of servicing that specific debt. And of course, if we on principle say that it can be reduced based upon debt, what are we telling the world? What are we telling people? That if you don't want to pay maintenance, incur debt, buy nice clothing, buy nice items, and so on, and then go to the maintenance court and say, okay, when the order was made, I had to pay 100 rand because I was only in debt of 20 rand, minimum debt. This 1 or 2 accounts. But now I've lived lavishly. I went on holidays on my credit card. I purchased nice clothing. And now I am 5,000 rand in debt. The maintenance amount is 100 rand. And my salary is 1,000 rand. I'm in debt. What are we saying here? We are telling people that it's fine, to incur a great amount of debts, and at the same time put the responsibility now on the other parent to maintain the child. Because in that scenario, the mother would be left with the brunt to care for the child based upon the father living a good life, that got himself into debt. Where I'm going to with this is we need to look at all the circumstances, and if the father's debts are not reasonable, not justified, if his debts were based upon, paying medical expenses for the child, was for his personal medical expenses, something very important that makes is justifiable, that's a different ball game. But if it's silly debt and debt of living a lavish lifestyle, the court should take a robust approach and say, sir, the maintenance order still stands. You have to pay the maintenance order. If not, you make a plan. Go into further debt and pay the maintenance order, but make a plan. So my quick answer over there is depends on the circumstances, but generally, debt should not be a reason why the maintenance order should be reduced, especially if the child has special needs. Thank you for that question. I have another question. If the parent's time is split 40-60, 60 to the mom and 40 to the dad, and he says he should pay maintenance also, if he says he can't pay, can the parents be held liable? Can his parents be held liable? I presume the general question would be, can paternal grandparents of minor children be held liable for maintenance? The general rule or the law, grandparents can be held liable for maintenance if their specific kids can't afford to pay the maintenance. Therefore, if a father can't afford to pay maintenance, and then they can approach his parents to pay maintenance. But I also believe then you have to look at both sides, the maternal and the paternal side of the scenario. Yes, you can. If the father truly cannot afford to pay the maintenance, then you may approach the maintenance court. You first need to deal with the inquiry regarding the father. Okay, I see the person says he shouldn't pay maintenance. No, he should pay maintenance. Okay, but let me first deal with the issue concerning claiming maintenance from grandparents. You can't go directly against the grandparents. That doesn't make sense. Grandparents live their life. They've brought up their kids. They've paid their support. They've paid their dues. If, however, there's a scenario after a full-blown inquiry and it comes about that the father cannot pay child maintenance, or he can pay limited child maintenance, but the child requires additional maintenance, and also we looked at the circumstances on the mother, then under those circumstances the inquiry can go into whether or not the father's parents can come into the picture and assist in paying the child maintenance. But in my view, then we have to look at both sides of the scenario. We also have to look at the maternal side. It will be unfair for the paternal side to only be responsible for that shortfall in maintenance without looking at the maternal side, despite the maternal side being extremely wealthy. So therefore, for argument's sake, let us say the child cost 100 rand, and the mother, based on her salary, she can only afford to pay 20 rand. Now they do an inquiry and they find out that the father can only also afford 20 rand, but the child requires 100 rand, so there is 60 rand missing. Would it be fair to only proceed against the father's side for that shortfall? No. we need to now do an inquiry on both paternal and maternal grandparent side. But this specific father says now he does not want to pay. That's nonsense. You can't say that. Even if the mother cares for the minor child 60 and the father 40% of the time. How would that generally work is maybe the mother cares for the child Monday, Tuesday, Wednesday, Thursday. That's 4 days, and the father has the other 3 days, and so on. And then the mother again cares for the child Monday, Tuesday, Wednesday, Thursday, alternatively. But if that scenario does apply, we have to look at the circumstances. We still have to look at the income and expenditure of the parents. Despite the father caring for the kids 40% of the time, if, however, he earns much more than the mother, and we work out it proportionately based upon the expenditure which the father has and based upon the expenditure of which the mother has, there would be a legal obligation for the father to pay the mother maintenance. However, if the mother earns much more than the father and she has much more wealth, remember, maintenance is not only determined based upon your income, it's based upon your assets as well, your means. If the mother earns, for example, 10,000 rand per month and the father earns 5,000 rand per month, but he cares for the kids 40% of the time, and all else is equal, then I would say there's no legal obligation for him to pay maintenance to the mother. There might be an obligation upon the mother to pay the father maintenance to maintain the child, because he's caring for the kids, he's incurring expenditures for the kids, but the mother earns much more than him. So that's scenario is possible. I look at maintenance matters as mathematical equations. I take a spreadsheet, I analyze it from that basis because it needs to make logical sense at the end of the day. If the father is looking after the kids 40% of the time, he still has to provide a room, electricity, water, Wi-Fi. Those are now the new things now that's coming about in maintenance application forms, and so on. So he needs to still provide those provisions to the minor child. And the mother needs to do exactly the same. So the child has two households. The mother's electricity bill might be a bit more, her food bill might be a bit more. But if she's earning triple the father's salary, then she will have to pay the father some maintenance because he's caring for these kids for 40% of the time. So therefore, take a spreadsheet, work it out, what's reasonable and logical. Based upon that, you can determine. But there's no principle applicable that if one parent, even so, if the minor children are shared equally between the parents, 1 week, 1 week, 1 week, 1 week, it's still possible, and it happens regularly, where one parent has to still pay maintenance towards the minor child to the other parent. So I hope that answers that question. Okay. I have an additional question. Okay, going to the previous question regarding can maintenance be reduced based upon debt? The additional comment is, if debt is personal loans and vehicle debt. No, man, they had a choice. Personal loan, what did he do with that money? I didn't know what he done with that money. And vehicle debt is for vehicle. You can't hide behind those specific items not to pay maintenance. As I said now, there are scenarios, there are situations where it makes sense. But why must one party be prejudiced because you decided to live a lavish lifestyle or be irresponsible where debt is concerned? Like a vehicle debt, for example, if you need to have a reasonable vehicle, because you work in a dangerous area and you need to have this vehicle, otherwise you cannot work, then obviously you're allowed to have that specific debt because you have to pay it. But vehicle debt will be a monthly payments, monthly installments. Alternatively, if you took out a big amount, you took out a personal loan and you purchased a vehicle, and now you have to pay that loan and something happened to the vehicle. Where I'm going to with this whole answer is you need to look at the matter logically and reasonably. And if it's a reasonable debt, of course, he has to incur it. You can see it as an expense, a monthly expenditure. But if, for argument's sake, the guy earns 10,000 rand per month, he was flush at the start of the year, now he's in debt of 100,000 rand per month, 6 months later, clearly he was lavish and he wasted money. The court will have to consider that, and the court will consider that, and under those circumstances, he must make a plan to pay the debt, but he needs to continue paying the child maintenance. I have another comment regarding the issue of grandparents. no, this is a total different comment. If grandparents are not SA citizens and do not live in SA, can you claim maintenance from them? So the basic scenario would be, let's say mom and dad, father is most probably a American. He comes to Cape Town, they're in a relationship with a mom. She has a child. He goes back overseas. He passes away. That could possibly happen. Or he goes overseas and can't find him, or he doesn't have any reasonable wealth or income. Now you want to claim maintenance from the paternal grandparents. Now, those are tricky questions to answer because we have to go through a checklist first. The first thing I have to mention to you is South African law or South African courts or the South African government cannot advise another government what to do. South African court orders are not applicable in other countries. Countries are autonomous. Our court orders are only limited to South Africa, and the same way European, American, Russian, Arab countries, their specific orders are applicable to them. It makes logical sense. Imagine you get someone goes to America, lay complaint against you, an American court gives a warrant of arrest, and South African law must just follow the order. Countries are autonomous, and one country can't tell another country what to do. There are, of course, agreements between countries. For example, like extradition. If someone commits a crime in one country, in South Africa, for example, and he flees to a different country, there may be an agreement between South Africa and that country whereby they will send that person back to South Africa. But that's based upon, obviously, upon an agreement, an international treaty, and so on. The same applies to child maintenance. You can't make a maintenance order in South Africa and expect the maintenance courts that side to enforce it and execute it. Who are we to tell them what to do? I mean, they got their own laws, their own court orders, and so on. And the same way, if they send a court order to South Africa telling us to do something, we won't do it. We don't have to. Now, international maintenance, or the law that applies to that, is the Reciprocal Enforcement of Maintenance Orders Act, the REMO Act. You can Google it, it's REMO, or Reciprocal Enforcement of Maintenance Orders Act. Type it into Google and you should find one. I know the Department of Justice has a website dealing with that. There are certain countries around the world who entered into an agreement, South Africa is one of them, signatory countries, where the agreement basically says the following: we will assist each other in enforcing maintenance orders. The long and the short of it is, if there's a maintenance order in South Africa, you can have that order registered in another country. But there needs to be an agreement between the two countries. So I think South Africa has agreements with a few states in the United States of America. The basic principle on how it works is you apply to your local maintenance court. So the father is in the States, the grandmother is in the States. You live in Cape Town. You go to your local magistrate's court, Cape Town, Wynberg, Mitchells Plain, wherever it is. You advise him that the other party lives in the United States. The maintenance officer will go onto the website of the Department of Justice and find out, is this a signatory country? He decides, yes, it is. Wonderful. An inquiry will take place. Remember, we do not have any of the father's details over here. He's in the States, so we can't deal with him. An inquiry takes place. We deal with the issue concerning paternity, details of the father, what the child cost, what the mother's income is, her expenditure. So we do a full-blown inquiry here, but a one-sided inquiry. We don't listen to the other party because we do not know who the other party is, or we do not have jurisdiction over the other party, and he's in different province, in a different state, in a different country. That's done. So the maintenance court in Cape Town or in South Africa will now decide, we believe that a reasonable amount of maintenance for a specific child would be amount of 1,000 Rand. I'm using simple figures here. That specific order and all the documentation, supporting documentation through diplomatic channels, will, for example, diplomatic channels will be the Office of the Family Advocate or Director General in government, whatever person that is designated in the relevant legislation. So the REMO Act will actually explain that to you. It goes to that office, that department. It gets registered with them, and it gets sent via diplomatic channels to the other countries' receiving party, designated party. That could be the Office of the Family Advocate if they have one in the new country, the minister, whoever it is. So each country has a different person. They'll have their own act in place. That documentation goes there, and ultimately, I would presume it goes to the relevant court, the maintenance court or the family court, depending upon the country. They will call the father in, and they will do their own inquiry. They will look at the documentation that the mother has provided. They will look at the documentation that the father provides, what he says, his income, his expenditure. They'll do an inquiry that side, and then whatever order they make that side will be registered there, and of course a copy gets sent down to South Africa via diplomatic channels again. That is how the Reciprocal Enforcement of Maintenance Orders Act works, and how international maintenance orders are made if you live in South Africa, and vice versa as well. I was lucky or maybe experienced in dealing with both scenarios, whereby someone in another country applied for maintenance, and I was involved in Cape Town, assisting the process, where the father lived in Cape Town, and at the same time where the mother lives in Cape Town and she's applying for maintenance against the father in a different country. So that's a practical aspect of it. We can't necessarily answer how the other country works. You'll need to look at their specific law. Like we have the Reciprocal Enforcement of Maintenance Orders Act in South Africa. The states, whatever other country, they will have their own specific laws. So answering this question from the specific commenter, if grandparents are not SA citizens and do not live in SA, can you claim maintenance from them? So the first way to answer the question, number one, is it doesn't matter if you're an SA citizen or not. If you're not an SA citizen in South Africa and you live in South Africa, you can claim maintenance from that person. So you're not immune from the maintenance court, unless you're maybe like a diplomat or whatever the case may be. Going forward, you need to look at the REMO Act, to the specific commenter, find out if South Africa is a signatory to the Act. If the father lives in South Africa, the inquiry must first be finalized against the father. Then after that inquiry, and you still require more, the court here locally needs to process that inquiry in the States, by diplomatic channels. If the father is not in South Africa and the father is not being able to be found, and you only have the details of the grandparents who are living in the States, I'm using the States as an example, you need to make an application to the local court, and the local court will, through diplomatic channels, process the application. So that's a long and short of it. Please Google it. REMO, or Reciprocal Enforcement of Maintenance Orders Act. The Department of Justice got a nice, I think you can download the Act. And at the same time, there is a list of countries with whom South Africa has a reciprocal agreement with. Oh, the commenter says, thank you, you are welcome. I do not see any additional questions. If there are any, please pose it as soon as possible. I'll have to leave this webinar quite soon. I do appreciate all the comments. It's always valuable to have people comment so that I can answer practical questions, as opposed to just talking and advising you of what I think is reasonable or rational to speak about. But at the same time, the viewer might not find it rational or reasonable or relevant to his or her situation. Therefore, if you do provide me with live questions, I can at least assist one person, and maybe many other people with the same problem can benefit therefrom. Otherwise, tomorrow morning I'll be back online. It will either be 9:30 or 10 o'clock. If you have any questions, please feel free to pose it. And as I mentioned earlier on, you might later on watch this video on a different platform, our lawyer, for example. But please like the Advocate Muhammad Abduroaf Facebook page. That is a page from where we are streaming from, and there will be notification on that page. Type out the questions today, and tomorrow when I go online, it will either be 9:30 or 10 o'clock. More than likely 9:30. The moment I go online, pose the questions so we can get immediately on that. Have a wonderful day, and I hope to see you tomorrow. Thank you.